So here we have what should be hopefully the final part of this look at Michael Cicchini's excellent document that covers prosecutorial misconduct, specifically in closing argument. But of course, we know that people like Kratz are well skilled at prosecutorial misconduct right from the word go. Long before the case ever goes to trial, throughout the trial, and bizarrely, although he's no longer involved in the case, still trying to maintain that Steve is guilty and still coming up with ridiculous stories about how certain bits of evidence could have occurred. Anyway, let's share screen and let's go with the conclusion. So, conclusion: prosecutorial misconduct in closing argument is rampant. I would agree with you there. Unfortunately, defense lawyers' conventional reactionary approach to the problem is often ineffective and sometimes even exasperates the harm. Rather than following this ineffective approach, exposing the defense to potentially damaging objections in front of the jury, defense counsel should utilize a preemptive motion in limine to combat improper arguments before they are ever made. Doing so may prevent the prosecutor from making improper arguments in the first place and will alert the trial judge to the likelihood of prosecutorial misconduct. Most importantly, in cases where a preemptive motion in limine is granted and subsequently violated, the order will establish a framework for addressing the misconduct in meaningful ways, including providing the opportunity to draft thoughtful and effective curative instructions, affording time for client consultation before requesting the more serious remedy of a mistrial, and, in the event a mistrial is declared, potentially protecting the defendant from re-prosecution. So, Appendix A, motion in limine. The following is a sample motion in limine. Defense counsel should tailor all motions in limine and all in-court strategies to the jurisdiction's applicable substantive and procedure law and to the facts of the particular case. Further, counsel should ensure that all sources below are accurate, applicable, and have not been superseded by new law. If defense counsel believes a particular judge will not be receptive to this preemptive approach and lengthy motion in limine, counsel may still wish to file a much shorter motion without the introductory material, without seeking relief from the contemporaneous objection rule, and without itemizing the types of improper argument. Motion. The defendant, appearing specially by his/her attorney and reserving the right to challenge the court's jurisdiction, moves the court for the entry of orders as requested and pursuant to the authorities below. Improper closing arguments by prosecutors have become the norm in criminal trials. For several reasons: prosecutorial recidivism, the tendency of the same prosecutor or office to engage in misconduct repeatedly, even in the face of admonishments from the appellate court, is widespread. Although it is generally considered defense counsel's responsibility to protect his or her client from a prosecutor's misconduct in closing argument, there is also an affirmative duty placed upon the trial court to object on its own motion. The problem, however, is that a prosecutor's improper closing argument often poses difficulties for defense counsel and the trial court. On the one hand, objecting to improper argument is not only difficult to do in the heat of a jury trial, but may serve only to repeat and attract attention to the improper remark and thereby compound the prejudicial effect. On the other hand, though, not objecting fails to preserve the issue on its merits, often resulting in a time-consuming, ineffective assistance of counsel hearing and, in some cases, an even more time-consuming second trial. In sum, prosecutors routinely make improper closing arguments because they are highly effective, difficult to counter, and rarely, if ever, punished. Therefore, the bar, and particularly the bench, should be aware of the phenomenon and take measures designed to increase the risks for those attorneys who persist in this strategy. The defendant therefore seeks to address these matters preemptively to 1, deter the prosecutor from making improper arguments in the first place, 2, promote general trial efficiency, 3, avoid potentially counterproductive harmful objections during closing arguments, 4, greatly reduce the likelihood of costly and time-consuming post-conviction hearings and a subsequent retrial, and 5, put the prosecutor on notice that improper argument will provoke a mistrial request by the defendant. Therefore, the defendant moves the court to order the prosecutor not to engage in the forms of improper argument set forth below in motion in limine number 5. The defendant moves the court to order that if the prosecutor engages in such forms of argument, the defendant's objection is preserved. Based on this motion in limine and without the need for a contemporaneous objection at trial, A, when defense counsel raises an issue in a pre-trial motion in limine to require an additional objection at trial would place defense counsel in a classic catch-22 position. By not objecting, counsel is held to waiver. By objecting, counsel draws the jury's attention to the very argument that the trial court had already ruled improper, recalling that one of the purposes of the contemporaneous objection rule is fairness. Therefore, the defense counsel moves in limine to preclude the prosecutor from making an improper argument at trial, and the court grants the motion. Counsel is relieved from having to object to the same issue of fact or law that arises at trial. Finally, despite being relieved of the obligation to object, defense counsel still has the right to object to improper argument when doing so would be in the best interests of the defendant. For example, where an objection might terminate an improper argument before the jury is able to feel its full impact. 3, the defendant moves the court, if defense counsel so requests at the conclusion of the prosecutor's rebuttal argument, to hold a conference outside the jury's present and before it receives its final instructions from the court. The purpose of the conference is to discuss remedies for any improper arguments made by the prosecutor, including but not limited to the remedy of curative instructions. A, many instances of improper arguments, including, for example, arguments that misstate the burden of proof, can be adequately addressed by a curative instruction from the court. B, however, pattern instructions and generic curative instructions that merely state the obvious, for example, that the words of the attorneys are not evidence and must not be considered by you as evidence, are not legally sufficient to cure the prejudicial impact of improper argument. C, therefore, a post-argument pre-jury deliberation conference will allow the court and defense counsel to craft effective curative instructions that are tailored to the specific improper arguments. 4, the defendant moves the court to order that, in addition to any curative instructions issued by the court, the defendant's right to request a mistrial as a remedy for improper argument is preserved and may be exercised at any time before the jury returns its verdict. More specifically, A, some types of improper argument may be too clearly prejudicial for even a well-crafted curative instruction to mitigate their effect. However, a mistrial may result in a retrial, which can be costly for a defendant, both in terms of his money and, when unable to post bail, his liberty. That is, even though a mistrial is the only remedy certain to ensure that the prejudicial conduct will not taint the ultimate verdict, its application may unfairly burden the defendant. B, given the severity of the mistrial remedy from the defendant's standpoint, counsel should not request a mistrial until after careful consultation with the client. This can be accomplished after jury begins its deliberations and before it returns its verdict to the court. Wisconsin law even holds that counsel may move for a mistrial before the jury returns its judgment. C. This motion in limine will also serve to put the prosecutor on notice that improper arguments, including those set forth below, will provoke the defendant's request for a mistrial and may bar the state from retrying the defendant. If a defendant's motion for mistrial is prompted by prosecutorial or judicial misconduct, which was intended to provoke defendant's motion, or was otherwise motivated by bad faith or undertaken to harass or prejudice the defendant, or to afford the prosecution a more favorable opportunity to convict the defendant, double jeopardy does bar further prosecution. Finally, the defendant moves the court for a pre-trial order that the prosecutor not engage in the following forms of argument. A. If the defendant testifies, argument that the defendant has a motive to lie because he or she is charged with a crime and or is facing a criminal conviction. 1. Such an argument would render meaningless the defendant's constitutional right to testify in his or her own defense and would contradict the court's instructions to the jury that the defendant has testified in this case and you should not discredit the testimony just because the defendant is charged with a crime. 2. Such an argument is improper because it implies that a defendant is presumed to lie simply because of her status as a defendant and because it diminishes the defendant's fundamental right to the presumption of innocence. B. If the defendant does not testify, direct or indirect comment on the defendant's silence during and or before trial. First, comment on the refusal to testify is a remnant of the inquisitorial system of criminal justice, which the Fifth Amendment outlaws. This includes indirect comments, including reference to uncontroverted testimony when the only one who could have controverted it was the defendant, who remained silent throughout trial. Second, when the defendant does not testify, her silence before trial, whether pre or post Miranda, is not admissible, and comment thereon would also violate the Fifth Amendment. C. If the defendant testifies, accusations that the defendant lied or is a liar or other inflammatory name calling. Branding the defendant a liar is inflammatory name calling that usurps the juror's role and duty to weigh the testimony of witnesses and decide witnesses' credibility. Similarly, other name calling is not relevant and highly prejudicial. Reversing conviction for prosecutor's argument that defendant was chronic alcoholic. Disparaging the defense counsel or counsel's role in the criminal justice system. For example, the argument that defense counsel's job is to get his client off the hook, and similar arguments are improper and deserving of condemnation. Disparaging remarks directed at defense counsel are reprehensible and could lead the jury to believe that the defense's characterization of the evidence should not be trusted. Yes, here's another one. Vouching, including the expression of a personal opinion about a witness's truthfulness on the guilt of the defendant. 1. First, a lawyer shall not in trial assert personal knowledge of facts in issue except when testifying as a witness, or state a personal opinion as to the justness of a cause, the credibility of a witness, or the guilt or innocence of an accused. Second, it is also improper to vouch for a witness by referencing matters not in evidence. For example, it is improper to vouch for police officer witnesses by telling the jury they work hard, they do a tough job, they work long hours. You weigh their testimony against the defendant's. F. Argument that incorporates facts not presented in the evidentiary portion of trial. It is improper for a prosecutor to provide the jury with information which allows the jury to consider facts not in evidence when determining guilt. Reversing conviction for prosecutorial misconduct, including prosecutorial testimony in closing argument that the defendant was unable to cross-examine. Okay, argument that misstates the law, including but not limited to the state's burden of proof. For example, arguing that the jury should search for the truth is improper because it misstates the jury's duty and sweeps aside the state's burden. Seeking the truth suggests determining whose version of events is more likely true, the government's or the defendant's, and thereby intimates a preponderance of evidence standard. This distinction is accurately captured by Vermont's instruction to its jurors, stating that if they have a reasonable doubt, they must find the defendant not guilty, even if they think that the charge is probably true. 2, even prosecutors admit that jury trials are not searches for the truth. For example, when a defendant is acquitted at trial and the state later tries to use the facts underlying that acquittal as other acts evidence in a subsequent trial, prosecutors have argued and Wisconsin courts have held that an acquittal only establishes that there was a reasonable doubt in the juror's mind as to whether the defendant committed the prior crime, not that the defendant is innocent. H, argument that creates straw men or misstates the defendant's theory of defense. For example, when the defense argues that the police officer witnesses were mistaken about the perpetrator's identity, the prosecutor is not allowed to misstate this defense by arguing, while defense attorneys try and say, well, we're not saying the police are lying, what else are they saying? This straw man argument improperly expresses the prosecutor's self-imploded frustration at his own suggestion that testifying police officers may have lied. I, argument that invokes the emotions of the jurors or directly or indirectly invites them to decide the case on matters outside of the evidence. Arguments appealing to the jurors' emotions and inviting the jury to consider the social consequences of its verdict are improper. More broadly, comments that invite conviction for reasons other than because the defendant was proven guilty beyond a reasonable doubt are improper. J, in rebuttal, argument that goes beyond the scope of the defense counsel's closing argument. First, the prosecutor's rebuttal argument is narrow in scope. Rebuttal shall be limited to matters raised by defense counsel in argument. Second, improper arguments are not justified and in fact are most harmful in the rebuttal portion of closing. And for the prosecutor to justify improper argument under the invited response doctrine, all of the following must be true. 1, there first was an improper argument by defense counsel. 2, the prosecutor objected to the defense counsel's improper statements with a request that the court gave a timely warning and curative instructions to the jury. And 3, the curative instruction was insufficient. Holding prosecutor's improper argument was not an invited response due to failure to object to defense counsel's improper argument. Appendix B, curative instructions. The following are examples of curative instructions for improper arguments. The instructions can be used as a template, but must be crafted to the particular argument and the applicable law in the case at hand. A, curative instruction for prosecutor's argument that the defendant's testimony should be discredited because he or she is charged with a crime and or facing a penalty. Quote, the defendant testified in this case and denied the allegation. The prosecutor argued or implied that you should disregard the defendant's testimony because he or she is charged with a crime and stands to be convicted. This argument is not valid. If the argument were valid, then every defendant who denied the charges against him would be guilty merely because the prosecutor filed a criminal complaint. That is not the law. The prosecutor's argument was therefore not proper, and you must disregard it entirely. As I previously instructed you, the defendant is presumed innocent. You must not discredit his or her testimony just because he or she is charged with a crime, and you may not convict him or her unless, after your deliberations, you find that the state proved every element of the charged crime beyond a reasonable doubt. B. Curative instruction for prosecutor's comments on the defendant's decision not to testify. This type of improper argument does not lend itself well to a curative instruction, as the argument directly implicates a fundamental constitutional right, and an instruction would merely draw additional attention to the defendant's decision to remain silent. In these cases, while crafting a curative instruction is possible, a mistrial request should be considered. C. Curative instruction for prosecutor calling the defendant a liar or other derogatory names. During closing argument, the prosecutor called the defendant a liar and implied that you should accept that conclusion and discredit the defendant's testimony. The prosecutor's comment was not proper, and you must disregard it. Issues of witness credibility are for you, the jury, to decide. Or, during closing argument, the prosecutor called the defendant a name here. The prosecutor's name calling was not proper, and that kind of tactic is demeaning not only to the defendant but also to the court and to these proceedings. You must disregard the prosecutor's comment and base your decision on the evidence or lack of evidence in this case, applying the burden of proof of beyond a reasonable doubt, as I have instructed you. D. Curative instructions for prosecutors disparaging remarks about defense counsel. During closing argument, the prosecutor said the defense counsel described derogatory comment. This argument is not proper. It is demeaning not only to defense counsel, but also to the court and to these proceedings. The defense lawyer is a critical part of our criminal justice system. The state has a tremendous power and resources to pursue convictions, and one of the defense lawyer's roles is to vigorously challenge the state's case to protect his or her client from conviction unless the state can prove guilt beyond a reasonable doubt. We all benefit from a system where defense lawyers vigorously defend their clients. You must therefore disregard the prosecutor's comments entirely, and you must reach your verdict after a careful consideration of the evidence or lack of evidence in this case, applying the burden of proof of beyond a reasonable doubt, as I have instructed you. Curative instruction for prosecutors vouching. This form of misconduct is so varied and includes both direct and indirect forms of vouching that any curative instruction must be specifically tailored to the particular improper argument. F. Curative instructions for prosecutors' argument incorporating facts not in evidence. In closing argument, the prosecutor said, describe prosecutor testimony. A good one would be Ken Kratz saying that the bloody handprint on the back of the RAV4, that's Steve's blood. He knew it wasn't, but he was still going to get that in there to try and boost a conviction. However, the purpose of closing argument is for the lawyers to discuss evidence that was introduced at trial. The prosecutor's statement that described prosecutor testimony was never introduced at trial, and the defense lawyer had no chance to cross-examine it or to present evidence to disprove it. You must therefore disregard the prosecutor's statements on this matter and instead base your verdict only on the evidence or the lack of evidence from the trial. G. Curative instruction for prosecutor misstating the burden of proof. The prosecutor argued that, describe prosecutor argument, this argument misstates the burden of proof. The law, as I have instructed you, is as follows. You must start with the presumption that the defendant is innocent of the charge against him. The state has the burden to prove each and every element of the charged crime beyond a reasonable doubt, even if after your deliberations you conclude that the allegation against the defendant is probably true. That is not proof beyond a reasonable doubt, and you must therefore find the defendant not guilty. Curative instruction for the prosecutor's straw man arguments and or misstating the defendant's theory of defense. The prosecutor argued to you that, again, describe the argument, and then attributed this argument to defense counsel. That was not proper. Defense counsel never argued that. They described the argument. You must therefore disregard the prosecutor's comments. The theory of the defense in this case is, describe actually theory of defense. You must return a verdict of not guilty unless, after your deliberations, you find that the state proved every element of the charged crime beyond a reasonable doubt. I, curative instruction for prosecutor arguments invoking juror emotions. This type of improper argument does not lend itself well to a curative instruction, and as it is particularly difficult to unring the bell once emotions have been stirred. For example, prosecutor arguments that society, children, or even the jurors themselves will be at risk of harm if the defendant is acquitted are highly damaging. In these cases, while crafting a curative instruction might be possible, a mistrial request should seriously be considered. Curative instruction for prosecutor arguments going beyond the scope of rebuttal. If the prosecutor went beyond the scope of rebuttal, but merely repeated an otherwise proper argument made in his or her first closing argument, a curative instruction is not likely to be effective. Further, trial judges may be unwilling to give an instruction under these circumstances. 2, if the prosecutor went beyond the scope of rebuttal by making a new but otherwise proper argument, an instruction explaining the purpose of rebuttal combined with a directive to disregard the prosecutor's comment may be effective. 3, if the prosecutor went beyond the scope of rebuttal by making an improper argument, the curative instruction would include the language in instruction J2 above, and the instruction's substance would depend on the specific form of improper argument. And that is the end of that. So, hope you've enjoyed this fantastic article that was written by Michael Cicchini for the Oklahoma Law Review. Michael certainly knows his stuff, doesn't he? I think he's the only one that's written 2 books about Stephen Brendan's case. Hopefully I'll get a chance to speak to him soon, but he did say he was quite busy, and with knowledge and expertise of his, one could imagine how busy he is kept. Anyway, catch you all again soon. Take care. Bye for now.